Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as those in Las Vegas, and of course, anyone watching online. With that, Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Here. Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Orentlicker.
Here.
Roth.
Here.
Yurt.
Here.
Chair Miller.
Here. Thank you so much. Just a few housekeeping reminders. Please make sure you turn down your electric devices. Again, a reminder that today's agenda is posted on Nellis. You can watch today's meeting through Nellis or through the YouTube website. Nellis, the agenda that's posted on Nellis also has the call-in number and meeting ID for later. We ask that presenters keep their presentations to 15 minutes and that anyone making public comment or testifying on a bill keep their remarks to 2 minutes. Please remember, for everyone speaking, to please state your name first, and the first time you say your name, we ask that you spell it so that we have it correct for the records. With that, we will begin with, we have two committee BDR introductions, so we will begin with that first. The first BDR is BDR 5494, and this is relating to juvenile justice, granting the juvenile court limited jurisdiction over certain persons who are 21 years of age or older and providing other matters properly relating thereto. So with this, again, members, this is just a BDR introduction, and I'm just asking that it goes forward to a bill. With that, are there any questions? I will take a motion.
So moved.
I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Moore. Members, any further discussion? With that, all those in favor, please say aye.
Aye.
Anyone opposed? And the measure passes. I have a second BDR introduction for BDR 4874. This is relating to cemeteries, revising provisions relating to the disinterment and removal of human remains from certain cemeteries, revising certain requirements applicable to certain cemetery owners, and providing other matters properly relating thereto. Members, any questions? Can I have a motion? I have a motion from Vice Chair Marzola and a second from Assemblymember Gray. Any further discussion? All those in favor, please say aye. Aye. Anyone opposed? And the motion carries. Thank you so much, members. With that, we will go on to our first agenda item, which is Assembly Bill 239. Assembly Bill 239 revises provisions relating to business entities. With that, I will welcome the bill sponsor up. And we will have co-presentations so that everyone understands between here in Carson City and Las Vegas. With that, Assemblymember Dahlia, when you are ready and settled, you may begin. Again, I ask that everyone introduce themselves and spell their name correctly for the record.
Thank you, Chair. Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. For the record, I am Joe Dahlia, Joedalia, Assemblyman for Assembly District 29. Today, it is my pleasure to introduce Assembly Bill 239, the first bill of my legislative career. Assembly Bill 239 is a proposal put together by the Business Law section of the State Bar of Nevada to update and refine our business laws. I am sad to report that for the better part of a decade, I have worked in corporate law and am therefore tragically more familiar with this bill and its subject matter than any human should be. But I am proud to bring this bill and very thankful for the Business Law Section's efforts and collaboration. I believe this bill will strengthen Nevada's business law statutes, ensuring predictability for those that do business in our state, clarifying our statutes to avoid potential ambiguities and uncertainties, and keeping Nevada competitive by evolving with trends in corporate law. We appreciate the diligence by the section to ensure Nevada is keeping pace with other states like Delaware and Texas, yet carving out its own path when it serves Nevada's best interests. Delaware, often referred to as the gold standard in business, but in recent years, in part due to the section's biennial bill, Nevada has made great strides. Today, because of these efforts session after session, we pose a legitimate threat to Delaware and its incredibly lucrative corporations market. My apologies. This bill will continue to move us forward in that effort. Before I let my co-presenters take the wheel, I want to take a moment to commend their efforts to stay nimble in developing a friendly amendment to keep up with real-time changes in law. Right now, corporate law across the country is shifting rapidly as states try to compete to be the go-to destination for incorporations. In the past few weeks, Texas and Delaware have both introduced bills to overhaul their corporate laws for that very reason. The friendly amendment we'll be presenting today is carefully crafted to help us keep pace with those states without overextending ourselves. Now to officially turn to my co-counsel, with me this morning in Carson City is Rob Kim, the chair of the Business Law section. Also part of today's presentation, down in Las Vegas, are Mackenzie Warren Kay and Albert Kovacs of the law firm Brownstein Hyatt Farber Schreck. Mr. Kovacs co-chairs the Business Law section. At this time, I will turn this presentation of AB 239 over to Mackenzie Warren Kay in Las Vegas. Thank you.
Thank you, Assemblyman. Good morning, Mackenzie Warren Kay, Warrenkay, with Brownstein. On behalf of the Business Law section of the State Bar of Nevada, Assemblymember Dahlia is right. I don't think I've ever had a sponsor that actually understands this thing through and through. As he mentioned, this is his area of practice, so we're especially lucky to have his expertise. Thank you, Chair, for hearing the bill. For members, we've put together a summary memo that is posted to Nellis as a guide that will walk you through the bill section by section, as well as the friendly amendment. And by way of brief background, the section is comprised of corporate lawyers that practice in this area. So they are the ones that are interfacing in these statutes and really understand what needs tweaking. And so each session, the section comes up with a bill, much of it technical cleanup, some innovation, and then some areas of development for business law. Just a quick disclaimer, except as noted in the chart, the proposed amendments have been approved by the Board of Governors of the State Bar of Nevada. And what this approval does is it allows the section to advocate for AB 239, but it does not represent the position of the Board of Governors or the State Bar, the general membership, or the business law section itself. Now that the disclaimer is out of the way, Chair, with your permission, I will toss it over to Rob Kim in Carson City to walk you and members through the bill. Thank you.
Good morning. Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. My name is Robert Kim, R-O-B-E-R-T-K-I-M. I am a partner with the law firm of Ballard Spahr. I'm here in my capacity as chair of the Executive Committee of the Business Law section of the State Bar of Nevada. I've been a practicing lawyer here since 1996, and I've been testifying on this committee's bills for approximately 20 years. What I'd like to do today is merely identify key aspects of the bill that I'd like to bring to your attention using the summary that was provided to you as a guide, and I'll walk through that, noting which ones I will be pointing out. Some of them, as noted, are more technical, cleanup, consistency related, and there's a handful that merit a further discussion and just highlighting that what we're trying to accomplish with those amendments. So I'd like to just go through that right now. Starting with Section 2 of AB 239 that relates to Section 78138. This relates to the duties of officers and directors, and this is merely a cleanup change because we wanted to conform the statement of fiduciary duties for directors and officers to the presumption that is also contained in the statute. And so right now, directors and officers are required to exercise their duties in good faith with interest in the best interest of the corporation. And the presumption is a little different. They're presumed to act in good faith on an informed basis with the view of the interest of the corporation. So we're just adding on an informed basis as part of the general fiduciary duty statement to directors and officers. The next item I wanted to highlight is Section 6, NRS 78315. And this makes clear that when a board of directors approves various transactions on behalf of the corporation or recommends them for approval to shareholders, to stockholders, that they are able to do so and act accordingly based on substantially complete drafts and not final form. This is a common practice in business transactions to have a substantially complete form And obviously, items like pricing and other small details are left out because those are usually not done until the final moment. So this is appropriate just to recognize there's been instances where this has been challenged because they did not approve the final document, but in practicality, that's just not very feasible in this day and age. So merely just trying to clarify the discretion that the board has in terms of adopting agreements and other transactions. The next item is item 8, relating to section 78390, subsection 1. And what this does is it allows a corporation, only publicly traded corporations, to permit amendments to their charter documents to increase the authorized shares on a standard that is on par with other proposals submitted to the stockholders. And the difference there is that usually amendments to the charter require a absolute majority vote of the voting power. But with public companies with the widespread retail ownership and the fact that most people receive please vote cards or mail emails that I take in one hand and literally drop into my recycling bin on the other hand, that this is hard to gather an actual majority of the voting power for public companies. And so this allows proposals to be approved by the standard adopted in the bylaws, which is generally almost always a majority of the voting power present at the meeting. So those that are present, once a quorum is established, those that are present, a majority of those votes present are allowed to approve of this amendment only for the purposes of increasing the authorized shares. So it's very narrow, but it's something that it will help a lot of struggling companies that are not able to have the sufficient capital available for fundraising and obviously sustaining their operations. Next item I want to point you to is our sections 22 and 24 of the bill, and they relate mainly to a new section that we are proposing, and it is a section that will allow a current Nevada corporation to, by statute, create a holding company structure in one fell swoop with one document. Now, what that does is it takes the company. Most companies operate, privately held companies that operate directly as a corporation. Like that corporation owns the land, they own the operations, they hire the employees, they contract business. Usually as companies get more mature, they actually operate through a holding company, which then owns the operating subsidiary, just to separate the different roles and the functions of the two different levels of the corporation. So most publicly traded corporations, for example, usually are publicly traded, and then they have wholly owned operating subsidiaries underneath, if not one, multiple. And so what this does is it allows a corporation to convert to a holding company structure by statute instead of doing it through various steps. The next item I wanted to point out is section 23 of the bill that relates to 92A 120. In this bill, we did a few things here. One is we wanted to just make very clear what the process is for a plan of merger to be approved by a corporation. It requires a board recommendation of the plan and stockholder approval, and that has not changed. Although the wording has changed because we're just trying to clean up and make it more clear, the actual requirements are not changing. We did try to eliminate the concept of special circumstances. In Nevada, a board is required to maintain the recommendation of a plan of merger to the stockholders until the stockholders vote on it. And with the exception of special circumstances, a term that has never been defined under Nevada law, hasn't really been defined in other jurisdictions. And if anything, we were able to locate, a committee member was able to locate an example of when a special circumstance might exist when a recommendation cannot be given. And we clarify that in the statute so that it's when there's some issue with the number of directors, for example. They say there's an even number of directors, and they can't necessarily recommend the transaction because of that split vote. And so we try to make sure that the special circumstances wasn't used as some backdoor to somehow undermine a transaction that was normally approved by the board. In addition, we thought it was appropriate to also delete subsection 10, which provided just a general statement that the board may withdraw the recommendation. And again, I think that was adopted back in 1997 or 99 in response to certain anti-takeover transactions of the day, But in this day and age, with the various clarifications we've made to date, it made sense to remove that because the standard that we have is very clear, and we didn't want something to just obfuscate why the board is acting the way it did. And then the last two items I want to talk about occurred after the Board of Governor approval process. So as mentioned by the disclaimer, as mentioned in the memorandum, these two items came up afterwards, and they're in direct consideration of just recent corporate governance developments that happened in this year. And the first is to allow a corporation to allow a waiver of the jury trial, for terminations of for disputes or determinations relating to internal actions. The reason why this is being proposed is because it'll provide more certainty to corporations and management as to what the process is when you are presenting to a judge versus to a jury. And we're finding that this trend is occurring or being picked up with other jurisdictions as well as we speak. And the last item relates to the concept of the fiduciary duty of controlling stockholders. This has been an issue that is hard to pin down. It has been subject to case law for the most part, but we're hoping that by providing some basic framework, we can at least provide a little more predictability to Nevada corporate law with respect to controlling stockholders. And we define a controlling stockholder as a stockholder who can control the vote of a majority of the corporation's directors. We thought that was an appropriate threshold because the directors are the ones who are being delegated with the day-to-day management of the corporation. We also state that stockholders generally do not owe fiduciary duties merely as a stockholder. And we also state that the only duty that a controlling stockholder does owe is that they are to not exert undue influence on directors and officers, where such undue influences results in a breach of the fiduciary duty provided for under 78-138. And so we think this statute would bring a lot of clarity to an area that is very unclear, and also because in Nevada, just because of the way the judiciary is structured, we don't come by decisions very often, so we thought it was appropriate to at least provide a framework that people can work from in this potentially confusing area of law. So with that, I will conclude my formal remarks on the bill, and I'm happy to answer any questions that the committee might have.
Thank you for your presentation. We will begin with a question from Assemblymember Cole.
Good morning. Thank you for the presentation. I think you summarize this all very, very well, and I appreciate what you're trying to do for us. This is great. My question is in section 22, when we talk about that one foul swoop mechanism for the holding companies and the subsidiaries. And my question is related to the real property transfer tax that is collected by the jurisdictions when there's a transfer and conveyance of property. And I just want to make sure that this doesn't create some unintended loophole where the structure can be set up in a way that avoids that payment of tax. Thank you.
Robert Kim, again, for the State Bar Nevada Business Law section. In response to that concern, my understanding is that the policy is to allow corporations to reorganize. And so I think, based on my understanding of the current exemptions to the real property transfer tax, transfers amongst wholly owned entities is currently exempt from taxation. And so this would not create any change in ownership as it relates to the holding company versus the subsidiaries that are being created. So thus it should still align with the policies of the current exemptions. And I don't believe that it would be anything different from current transfers that are done between wholly owned entities.
Thank you. Our next question is from Assemblymember Ordlicker.
Thank you, Chair, and thank you for putting in the work to do this kind of a bill. One thing I want to ask about, though, is in the introduction, you talked about how important it is for our state to be competitive in attracting corporations, if I'm remembering accurately. That makes me a little nervous because what might be good for corporations and what their leadership thinks is good might not be good for the public. I understand that they have their fiduciary duties and all that, but nevertheless, sometimes we see a divergence. And as I went through the changes, not a lot popped out. Maybe the waiver of a jury trial, depending on who might be bringing these, shareholders versus corporate board. Maybe judges are more sympathetic to corporate boards than to shareholders. So anyway, can you assure me that we're not selling out the public when we try to be competitive with Delaware?
Robert Kim, again, for the State Bar of Nevada Business Law section. One thing that, I guess, given my length of involvement with the business law section, I know, in 1991, there was a wholesale change in Nevada corporate law or business entity laws that were designed to provide flexibility to all involved, management and to stockholders. And so I think from that point in time, there's been a desire to streamline, make efficient, but also make flexible how Nevada entities are used. And I think from that point in time forward, I believe that the filing fees received by the Secretary of State have been material and have been used by not just the Secretary of State, but I think a good portion of those funds actually go to the general fund, if my understanding is correct. So I think, one, there's an overall policy about just generating revenue from the different people that are availing themselves to Nevada law. But I also agree that this should not be done at the expense of any particular constituent. And I think when we put these laws together, we definitely are trying to take usability, flexibility, as well as acknowledgement of different trends that we're seeing in corporate law jurisprudence throughout the nation in various states. And so if there's something in particular, I'm happy to explain maybe why something might be jumping out to you, as you said, as being maybe something you want to know more about. I'm happy to explain that, and to the extent that you may think that might have an undue impact on a certain particular group. But we definitely are trying to we're just trying to provide clarity and predictability through what we are doing. That's the main goal of our committee.
Thank you so much. Our next question is from Assembly Member LaRue Hatch.
Thank you, Chair. Thank you for answering our questions this morning. So I'm going to build off my colleague just a little bit. I know in Knocking Doors last fall, I didn't have one person say, I wish we were the Delaware of the West. And so I just wondered if you could speak to how is this going to positively impact the lives of our constituents?
Again, Robert Kim again, State Bar of Nevada Business Law section. And so, I actually don't like this Delaware of the West phrase either. We should be what we want to be, and not be viewed as merely some kind of reflexive copy of another jurisdiction. So I definitely agree that it does make me pause when I hear that. And so we do not do that. We have different standards for our statutes and different fiduciary duties that are owed and different requirements. Obviously, I think somewhere along the line, most states have some tie to the Model Business Corporation Act that is maintained and developed by the American Bar Association. But that being said, we don't reflexively adopt amendments that are made to the Model Business Corporation Act either. Now, I think one thing we're trying to do is by providing predictability and by providing new ways to confidently use Nevada business entities, is that we are allowing not only folks outside of the state, but also people in the state to use Nevada corporations with confidence. Because a lot of times startups are told, for example, as one subset, startups are told, you need to be a Delaware corporation, otherwise no one's going to invest in you. And it seems weird to say that a great Nevada startup is a Delaware corporation. It seems like, like if you're an Alabama fan, you have to fly an Auburn flag in your garage or something like that. I mean, it's something like that. The things just don't make sense when you hear that. And so I think what a lot of the committee tries to do is give our own constituents reasons to use our own entities. And I think that builds off and lets other people that want to make that decision of where they want to be a more informed decision, because we've taken the time to try to make the laws more clear and predictable. So I hope that answers your question.
Thank you. Our next question.
Chair, if I might, from
Yes,
Las Vegas,
please.
just to follow up on that response. Albert Kovacs, ALBERT KOVACS, with Brownstein Hyatt Farber Schreck, and also the Vice Chair of the Business Law Section. In response to the Assembly member's question about the benefit to the community writ large or the state in general, one thing I would also note is that the formation of a business entity under Nevada's laws, which sell themselves as predictable, common sense, and stable compared with Delaware, at least as of right now, someone forming an entity under our state's laws could be the opportunity for that business to give a first look or a second look to Nevada generally. And if they have a good experience with our corporate and business laws and our courts, that may be their only entree into saying, well, you know what, maybe I should take a look at Nevada's business climate generally, and maybe that's the opportunity to pitch actual physical operations here, which could lead to economic development and job growth. So just wanted to add that other bit of color there. Thank you.
Thank you so much. So based on that remark, and that's a concern that I have and a clarification that I need. We keep talking about establishing the business here, but again, there's a difference between, and Nevada has, I'll be very down the middle of the road here, experienced a lot from businesses that open here on paper, but don't have brick and mortar or physical operations here in our state. And it's important that we do have, as just mentioned, not just jobs and services, but also the overall process of what happens when that cycle of revenue is being reintegrated into our communities. So are we speaking of businesses and corporations just on paper, or are we speaking of entities that will have front doors and services here in our state?
Robert Kim, State Bar Nevada Business Law Section. So I do believe it is both. You know, businesses, no matter where they are, they have to make that decision of where to incorporate. And I guess theoretically they have a 1 in 50 decision to make where they want to incorporate. But one thing I think Nevada has a lot of ability to become a better place for its own citizens, as well as attracting businesses to relocate here. One, because of what we're trying to do on the corporate side, but also what I see being done on the business side in terms of like tax environment and other incentives. So at a minimum, I do believe we're helping our own citizens, our own fellow citizens, in terms of making sure that we're giving them the right vehicles that they can choose to use, instead of being told they need to use a Delaware entity or some other state's entities. And then I think we're also giving them people abilities to recognize that Nevada might be someplace they want to consider. There are other reasons to consider it, but then also the fact to know that the business laws or corporate laws are ones that are being recognized as being helpful for raising financings and also developing new businesses. So I think it's twofold. I think this will accomplish both in terms of helping our own fellow citizens as well as attracting new businesses.
And so just to clarify, when we're saying attracting new businesses, are we saying new businesses just on paper here in Nevada, or new businesses that are actually open here to serve the community in Nevada?
I think it will be both. I think obviously there's a whole series of companies that need to domicile somewhere for their different transactions and different assets that they hold. But I also believe that there'll be a segment that when they see the combination of factors that the state of Nevada can deliver, and they see that it has business laws or corporate laws that can help them in terms of their next steps of growth, I feel as though they would come here. And I think there's a lot of reasons to come here, and I tell that to clients all the time in my daily practice, the various benefits that Nevada has for them to relocate here or to think about incorporating here and having a presence here. But I think Nevada is still very early in that stage. I work with the University of Nevada, Las Vegas on their startups, and we are behind a lot of other areas in terms of that growth. And I think everything is very incremental. So we're trying to do everything we can to maintain, develop, and keep businesses that do develop in the university, for example. And one way to do that is to give them entities and laws that will be conducive to their growth and to third-party investment, and obviously growth overall.
Okay, thank you. I think Assemblymember Gray, do you still have a question?
Thank you, Madam Chair. I've got a question and then possibly a follow-up question if the chair allows. This one's directly for Assemblymember Dahlia. So we as a body have a great a great plan for addressing problems and stuff like that. But what I'm wondering is why are you bringing this bill? Is it to assist corporate America? Is it to assist the Nevada taxpayers? Another avenue for revenue? It kind of ties in with my colleagues' questions, but what's the actual impetus for this?
So this is Assemblymember Joe Dahlia for the record. Chair, may I go direct? Okay, thank you. It's twofold. I'm going to build a lot on my co-presenter's answers. Revenue is a big piece of this. I mean, that's one of the primary incentives for us to be competitive with Delaware, competitive with Texas. But this is part of a series of bills that's brought, as I believe, every 2 years to just make sure that we're keeping pace with corporate law. A lot of other states can move more quickly because they don't have a biennium structure, right? So they can kind of get things done. We only get to do it every 2 years, so we have to kind of put together a package of things that helps us stay competitive for that revenue and then bring them. So this is just the next bill in that evolution of bills to make sure we're staying competitive for that revenue. But there is also like a piece for our communities because this is going to help our homegrown startups and our homegrown businesses get some of these investment dollars. I have worked with venture capitalists in Silicon Valley who say they won't invest in Nevada-based companies. They'll make you reincorporate in Delaware. They might even make you move to California after reincorporating in Delaware. And that's a bleed on our homegrown talent and our homegrown economy, right? So this is one of those bills, and you're probably going to hear more about this with the next presentation. I have a sneaking suspicion that helps us build that homegrown ecosystem so that our talent and our money stays right here in Nevada. Thank you.
Thank you, Assemblymember Dahlia. Follow on real quick? Yes, please. Thank you, ma'am. Okay, so again, as a body, we're great at identifying problems, potential solutions. What we're not great at is looking at the secondary and tertiary problems that are formed by our solutions. Is the Secretary of State's office going to be able to cope with the additional workload, taxation? What aren't we seeing here is the question.
Assemblymember Joe Dahlia for the record. We are not aware of any secondary issues with this. We've had good conversations with the Secretary of State's office about what this might look like. They're very excited for the additional workload because it comes with additional funding. Those filing fees and franchise fees add up really quickly. So to the extent that might be part of the equation, I think they're very excited to have that increased bandwidth come their way. So thank you.
Thank you again, Mr. Dahlia.
Thank you. Vice Chair Marzola?
Thank you, Chair, and good morning. Thank you for your presentation. My question relates to Section 27 in the jury trial waiver. So essentially, if I'm reading this correctly, the corporations can require it or mandate it. How many other states have implemented this waiver?
Robert Kim, State Bar, Nevada Business Law Section. So in terms of the waiver, I guess the reason why the waiver concept has, we thought to bring it to the section in the bill, that is, matters currently, for example, in a state like Delaware are heard by the Chancery Court, which is, this is a court of equity, there is no jury, and it's just designed to hear matters and to rule on them with a certain level of predictability and pace. And so by allowing a corporation to adopt provisions that permit, that waive the jury trial feature, gives people that use Nevada corporations or entities, or just corporations actually, the ability to have similar predictability with respect to be able to have matters being presented to and decided by a judge versus one that would include a jury. Now, in practice, I in my 28 years of practice, I've not seen a internal actions matter being decided by a jury. It just hasn't come up. So, not to say that that's why we should adopt this, but more just for practical context. And then we just actually learned on Friday that the state of Texas is amending the bill to also have a similar jury trial waiver language to permit corporations to do that as well. And so I don't know of a state that has it in place currently. Some states do not need that because the way that their business disputes are resolved are already by structure without juries. But in terms of a state such as Nevada, we would be one of the first ones to do that. But again, it's something that we're seeing being talked about through various other jurisdictions. And obviously we've seen it materialize in Texas in terms of their own amendments to their own corporate statutes.
Madam Chair, if I might, from Las Vegas, Albert Kovacs. Again, just to flesh out that answer, and thank you, Vice Chair, for the question. This provision, even though many states, Texas sounds like they would be joining Nevada in this regard, the primary state for incorporations, Delaware, already has this as a mandatory rule. The cases that this provision would apply to are a very narrow scope of litigation. So this isn't consumer litigation, personal injury. This is basically kind of within the family internal corporate actions. All of those in Delaware are heard, as Mr. Kim said, in the Chancery Court, where jury trial is not even an option. What this statute does is it makes it an option for corporations. And the way it's written is important structurally because the provision that would include this waiver must be included in the company's articles of incorporation. And why that's important is because the articles of incorporation are kind of like the constitution of a state or a country. They're the hardest thing to amend. And so to put a provision in either this kind of provision would have to be in the original articles of incorporation so that everybody buying into the company would know the rules of the game beforehand. And if they didn't like it, maybe try to negotiate that out before they bought in, but it wouldn't catch them unawares. If it was an existing company that thought about implementing this type of waiver, it would require board approval and approval of the majority of the outstanding shares just to get that provision into the document. So it's not something that can be unilaterally imposed on the stockholders by management. It's something that would require stockholder approval to put in place, and it's simply an option. It doesn't mandate anything change unless the company, board, and stockholders decide to do so.
Thank you, Chair. And I appreciate that answer. Thank you so much. Because I know we keep going back to Delaware, and I know Delaware has a court of chancery and we do not. And so I just want to make sure I know that if this jury trial waiver is implemented in any contracts, just wanted to know how it would affect our courts. Thank you.
Indeed, and I would like to follow up on that line of questioning because that was also one of my questions. It sounds simple to say that we're just going to waive a jury trial and just put it in the articles of incorporation. The question is, can you give us an example then of when it's stating right now these internal actions? What are some examples of internal actions? And what are some examples, because you also stated that you haven't seen in your experience where a jury trial has decided or moved on these actions. So what are some examples of some of these internal actions?
Madam Chair, this is Albert Kovacs from Las Vegas. The internal actions that this would apply to are actually defined in the statute, already defined in 78046 with respect to the narrow scope of claims that corporations can already require be heard in certain courts, which have to include Nevada state courts. And so examples of those are derivative claims. For example, if a stockholder believes that the board of directors has done something inappropriate, and they bring a claim buyer in the name of the corporation, claims for breach of fiduciary duty by directors or officers, or actions that are seeking to clarify or interpret the meaning of the company's governing documents, the articles of incorporation, or the bylaws. That's really the full scope of the claims here. So it's a very narrow range of, as I casually call them, kind of inside the family disputes.
And how often has that happened here in Nevada?
Again, Albert Kovacs. In general, these types of claims are not uncommon. They're not particularly common. Anecdotally, I think over the last decade or so, the pace of these types of claims has gone down. That's strictly my anecdotal experience. I've never seen in my almost 18 years in Nevada as a corporate lawyer. I also have never seen one go to a jury trial, or honestly even get close. So this is not something that happens with great frequency, but it's certainly not unheard of.
Thank you. Our next question is from Assembly Member LaRue Hatch. Thank you. Okay, then I will ask my other question. So my other question goes back to, I believe it was in Section 8, about requiring just quorum for those that are present for a typical meeting. And I love your example because, yes, I know I get those, like for mutual funds and stuff like that. And it's like, and you're like, who are these people? And we just toss it or shred it, whatever, right? But my question is, can you give us an example or a picture of what this will actually look like? Because when you say the members present, that means if just 3 people are present, then 2, it's like we have quorum. So what does quorum look like? If you could just kind of detail that more.
Sure. Robert Kim, again, State Bar, Nevada Executive Committee. So again, to just frame the situation or the example, this is a publicly traded corporation that is calling a meeting of its issued and outstanding shares. In its bylaws, in order to properly convene a meeting, there must be a quorum. And quorum is anywhere from a majority of the votes outstanding to as low as maybe a third of the shares outstanding. And so what happens is if there is a properly called meeting where, say, there's 50.1% of the shares present, then the vote of those shares, yes or no, can carry the day with respect to the limited proposal of increasing or modifying the authorized shares for the corporation. And the reason why it's important is because some publicly traded companies don't even have the ability to even reach a quorum, let alone a majority vote. So they're almost paralyzed in a way because they're not able to increase the authorized shares so they can enter into financing transactions and or other abilities to generate cash for their operations. So hopefully that explains, gives you a little more context as to what that might mean.
Okay, so it would be 51% of the shareholders if they are present, if 51% of the shareholders are present.
Correct. If that corporate has that quorum standard, yes.
Okay, if it has that quorum standard. So what if it does not have a quorum standard?
Well, like I said before, the corporation's bylaws have minimum quorum standards that range from, I've seen from 1/3 to 50%. That's all. So there's always a floor.
Okay.
There's always a floor. It's not an issue of I have 1 share, you have 2 shares, so we have a meeting and you can then outvote me because we just have 3 shares out of 3 million shares that are outstanding. That's not the case because quorum is a floor, is a threshold amount that must be present for any action to be properly taken at a meeting.
Okay, thank you. That's what I was looking for. So I haven't seen any that have said 1/3, but I could see where anything could be in the article, so whatever stated will be, okay. All right, thank you for that. With that, not seeing any additional questions, I'll go ahead and open it up for testimony. For anyone wishing to call in, our phone number is 1-888-475-4499. Today's meeting ID is 818-2256-5843. And with that, we will begin here in Carson City with testimony in support. So anyone wishing to testify, please again, remember to state your name and spell it for the record, and please limit your comments to 2 minutes. With that, we may begin.
Thank you, Madam Chair. For the record, John Sandy, JohnSande, here today on behalf of the Las Vegas Sands and the Nevada franchised auto dealers. This has been an interesting conversation, and so I wanted to take a 30,000-foot view of the conversation and provide some testimony as to why making Nevada the best choice for business corporations benefits all Nevadan citizens, and I've been able to come up with about 5. Ensuring that Nevada remains a top choice for business and corporations is not just about corporate interests. It directly benefits Nevada workers, families, and communities, and here's how. First, job creation and economic growth. More businesses incorporating in Nevada equals more jobs. This is somewhat anecdotal, but I did use Google to see about 67% of Fortune 500 companies actually headquarter in Delaware. They have just surpassed the 2,000 mark for companies that have headquartered in Delaware. So I think taking that example shows that more allowing for more incorporation allows for more headquarters. And that also increases the demand for skilled workers. A strong business presence attracts high-paying jobs in finance, legal services, technology, and management. The second reason, and this is an important one, higher taxes and local revenue without raising taxes on residents. Incorporating businesses generates significant state revenue through fees, corporate filings, and other business-related expenses, revenue that helps fund education, infrastructure, and public services without raising taxes on Nevada families. Other states like Delaware rely heavily on business and corporation fees to support their economy. And by improving Nevada's business-friendly reputation, we can capture a larger share of revenue and invest that into programs that benefit all Nevadans. The third reason, it strengthens small business and entrepreneurs. A business-friendly Nevada benefits all businesses, not just the large corporation. Many small businesses in Nevada provide services to corporations, including catering, real estate, accounting, and technology solutions. It encourages innovation and entrepreneurship. As more businesses incorporate in Nevada, it fosters a culture of entrepreneurship where startups and small businesses thrive.
Your time is up.
All right.
Please feel free
I will
to.
keep there if anybody wants to know the other two. I'll come meet with you.
Thank you so much. Please continue.
Good morning, Chair and members of the committee. For the record, Paul Moradkin, Moradkhan, with the Vegas Chamber. First of all, of course, we appreciate the bill sponsor for bringing the bill forward, and we are in support of AB 239. As many of you know, it's important for Nevada to remain.
Sorry. Keep going.
It's important for Nevada to remain competitive, of course, as you've heard, in terms of this business law chapter. And as the questions have come up, the more business that incorporate in Nevada, of course, generates more fees. And that could also potentially lead to additional fee regeneration in terms of sales and use tax, modified business tax, local government business licensing, professional business licensing, and potentially property tax. So there is a compounding effect to the state for revenue and local governments as more corporations incorporate in the state. Also, corporations pay a much higher rate for a business licensing fee at the state level than LLCs or sole props. And of course, on the policy side, this bill, as you heard, also updates existing provisions, creates efficiencies, and just a change of corporate governance that allows Nevada to be one of those leading business-friendly states on the benefit for all Nevadans. Thank you, Madam Chair and members of the committee.
Good morning, Madam Chair, Vice Chair, members of the committee, Chelsea Capurro, CAPURRO, on behalf of the Urban Chamber. Don't want to keep going on what everyone has already said, but we appreciate this. It helps bring predictability to businesses, and we think it helps keeps Nevada corporate and business law competitive. Thanks.
Anyone else here in Carson City? Anyone in Las Vegas wishing to testify in support?
Thank you, Madam Chair. Amber Stidham, that's STIDHAM with Las Vegas Global Economic Alliance. And just as a regional development As a regional economic development organization, a key part of our mission is to extol the virtues of doing business in the state of Nevada, especially for out-of-state companies. We believe, and we thank the bill sponsor for bringing this forward, that AB 239 brings a number of provisions that will help and keep Nevada corporate and limited liability statutes modern, flexible, clear, and provide yet another reason why many out-of-state corporations are considering Nevada as one of the best states to incorporate. Not only would it solidify us as a state to establish ourselves as a top choice for businesses seeking to incorporate, but it does, as earlier mentioned, create a once-in-a-lifetime unique opportunity for us to make our state one of the most business-friendly, as corporate filings are shifting away, as you heard, from other states and seeking states like Nevada. And I will tell you, at LVGEA here in Southern Nevada, we are looking to identify companies out of the Delaware area to shift and move some of their businesses to our community. So we want Nevada to be number one for the state for business incorporated corporations per capita, and we would strongly urge your support. Thank you.
Is there anyone else there in Carson City? I'm sorry, there in Las Vegas? Not seeing anyone? Broadcasting, please open the lines.
If you would like to testify in support of Assembly Bill 239, please press star 9 now to take your place in the queue.
I'm sorry, what? Yeah.
Good morning, Madam Chair and members of the committee. My name is Brian Wachter. I'm the Senior Vice President of the Retail Association of Nevada. We want to thank the bill sponsor for bringing this forward, and in the interest of time, we would like to echo the comments of the previous supporters and urge your passage of AB 239.
Thank you so much. Will you please spell your last name, please? Or actually, your first and last name.
Brian, B-R-Y-A-N, Wachter, W-A-C-H-T-E-R.
Thank you so much. Broadcasting, next caller.
There are no other callers choosing to testify in support at this time.
Thank you. Then I will open it up for opposition testimony, starting here in Carson City. Is there anyone there in Las Vegas? Broadcasting, please open the lines.
If you would like to testify in opposition to Assembly Bill 239, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for testimony in neutral. Is there anyone here in Carson City that would like to testify in neutral?
Morning, Chair Miller, Vice Chair Marzola, members of the committee, Justin Watkins, W-A-T-K-I-N-S, on behalf of Nevada Justice Association. I want to thank the bill sponsor for communication on this bill and its intent and purpose, and the State Bar. We are in neutral position.
Thank you. Anyone else here in Carson City? Is there anyone there in Las Vegas that would like to testify in neutral? Broadcasting, will you please open the lines?
If you would like to testify in neutral for Assembly Bill 239, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 505, please press star 6 to unmute your phone. You may begin. Caller 505, you are unmuted on our end. Will you please unmute your phone?
Hi, this is Peter Guzman, president of the Latin Chamber of Commerce. I apologize. I want to be in favor of this bill. I tried clicking buttons earlier and for some reason couldn't get through. So may I proceed?
Yes, we will take your testimony in support. Please proceed.
I appreciate it very much. Again, Peter Guzman, president of the Latin Chamber of Commerce. We are very much in support of this bill, and we thank the bill sponsor for bringing it forward. We absolutely believe that this will keep Nevada corporate and business laws competitive, provide new solutions to old problems, create efficiencies by clarifying potential ambiguities and uncertainties. This also adds substantive revisions that differentiate Nevada from other jurisdictions that we're in competition with. So again, we are all about making sure Nevada is always business friendly, competitive, and really leading the pack. And I think this bill does that. So we are in full support of it. Thank you.
Thank you so much. We will return back to testimony in neutral. Broadcasting, is there another caller? Sorry.
If you would like to testify in neutral for Assembly Bill 239, please press star 9 now to take your place in the queue. Chair, there are no other callers choosing to testify in neutral at this time.
Okay, thank you. Then with that, I will go ahead and welcome the bill presenters back up for any final words.
Good morning again, Robert Kim, State Bar Nevada Business Law Section. Just want to thank you for your focus and your attention to this bill and its contents, and I appreciate the questions and comments, and I hope that we did our best to answer those questions for you, and we will hopefully request a favorable approval on our bill, and also the amendment, the friendly amendment that provides for the two other provisions that we've talked about, the jury trial and also the controlling stockholder statute. So thank you again.
Thank you. With that, I will go ahead and close the hearing on Assembly Bill 239, and I will open the hearing on AJR 8. AJR 8 is an Assembly Joint Resolution which proposes to amend the Nevada Constitution to provide for an establishment of a business court. Again, please introduce yourselves and spell your name for the record, and when you are ready, please proceed.
Thank you, Chair Miller, Vice Chair Marzola, members of the Assembly Committee on Judiciary. I am Assembly Member Joe Dahlia, Joedalia, representing Assembly District 29 in Clark County. It is my pleasure to be here today once again to present Assembly Joint Resolution 8, which proposes to amend the Nevada Constitution to establish a statewide appointed business court. With me here today in Carson City to present this measure is Professor Ben Edwards of UNLV's William S. Boyd School of Law, who is our state's top legal scholar in corporate law. This resolution is in many ways the culmination of 2 decades of work. Since 2001, Nevada has operated business court dockets in Clark and Washoe counties following a recommendation from the Legislative Commission's Subcommittee to encourage corporations and other business entities to organize and conduct business in Nevada, made during the 1999-2000 interim. These dockets, modeled loosely after Delaware's Chancery Court, have greatly improved our state's ability to adjudicate complex business cases and correspondingly our ability to compete with Delaware. However, despite the progress we've made and despite having some very talented judges on the bench right now, our system still suffers from certain structural limitations that put us at a disadvantage relative to Delaware in terms of business court expertise, predictability, and efficiency. AJR 8 addresses those limitations by constitutionally enabling the legislature in a future session to establish a statewide business court with appointed judges vetted and selected for their expertise in the relevant areas of business law. This court would exclusively handle intra-business and cross-business cases, such as disputes involving shareholder rights, mergers and acquisitions, fiduciary duties, and other similar business disputes. As Professor Edwards will detail, the potential benefits of this court are massive. Chief among those benefits, this will allow Nevada to compete more capably for the multi-billion-dollar corporate filings market by offering businesses greater legal predictability and efficiency. That in turn could lead to more businesses, particularly technology companies, physically relocating here given our substantial commercial real estate footprint and proximity to Silicon Valley. It will also promote expertise and efficiency throughout our judicial system by preventing the commingling of civil, criminal, and business cases within one judge's docket. Last but certainly not least, in discussions with stakeholders in the venture capital space, we've repeatedly heard that this court will boost interest for cross-state investments in Nevada-born startups and small businesses, fostering much-needed economic growth and diversification coming from our homegrown talent. In sum, the business court represents a very unique and lucrative opportunity for our state that promotes not only the quality of our judiciary, but also promotes some of our most pressing economic goals. With that, I will now turn the presentation over to my co-presenter, Professor Edwards, to provide additional background and walk you through the resolution. Thank you.
Thank you. My name is Ben Edwards, BenEdwards. And thank you again to the chair and the members of the Judiciary Committee for considering this issue. I'm a member of Nevada's Board of Finance and a professor of law at the William S. Boyd School of Law at UNLV, where I teach courses on business law. I'm also a co-author of a treatise on Nevada business and commercial law published by LexisNexis, and an editor of the National Business Law blog. I'm here to speak to you today in my personal capacity. I encourage you not to hold anything I say against Member Ohrenlichter. Nevada now stands as a leading contender on a short list of recommended states for business creators to use to create their business entities. States collect enormous sums from business entity fees. Delaware, the national leader, now collects over $2 billion in revenue attributable to business formation. In contrast, in 2024, Nevada collected about $211 million from commercial recordings and entity revenue. This number could go up or down depending on how businesses see the relative benefits of incorporating in Nevada against other states. It's my view that we should do sensible things to make that number go up. And Nevada has substantial room to grow. Every time someone decides to create a Nevada entity instead of a Delaware entity, a Texas entity, or a California entity, it creates more revenue for Nevada. The Delaware Court of Chancery drives much of Delaware's popularity because the global business community trusts Delaware courts will always have a sophisticated judiciary able to quickly move cases. This amendment aims to make it easier for founders to pick Nevada with confidence by creating a selection process that will allow outsiders to trust that 15, 20, or 30 years from now, they will have access to a business law judiciary with deep expertise in business law. Delaware knows that its appointed expert judiciary gives it an advantage, and it is watching Nevada closely. Delaware's governor recently warned corporations against going to Nevada and rolling the dice on Las Vegas. Let me quote Delaware Chief Justice Seitz speaking at a legislative hearing in Delaware on February 20th. The Court of Chancery and the Delaware Supreme Court have never been busier. We're deciding more complex disputes with high-profile litigants than ever before. Many of these business disputes are expedited, meaning that the judges have to interrupt their existing work and put expedited cases on the top of their already tall pile. We are unrivaled by any other judiciary in our country with exceptional speed, deciding multi-billion-dollar cases. We are the envy of other states who for decades have tried but cannot duplicate our secret sauce. Don't take my word for it. Here's what the folks that are involved with setting up a rival business court in Nevada said this morning about the Delaware judiciary and the challenges Nevada faces in setting up a specialized business court. And here is where he quotes me within less than 24 hours of publication of something about this resolution. One of the major advantages Delaware enjoys is its knowledgeable, dedicated, and extremely hardworking judiciary. Delaware indisputably has the most case law in hand to answer open questions, but putting that aside, Delaware can also hustle and move on an expedited basis to resolve matters. Without a specialized court with the expertise and bandwidth to move quickly, incorporators may still tilt toward Delaware because their courts can resolve huge disputes fairly swiftly. And wow, does Delaware move quickly? Recent statistics indicate that over 92% of Chancery Court cases are disposed of within 90 days. Statewide, Nevada statistics are not readily available, but a records request to the Judiciary Statistics Department revealed that for fiscal year 24, the average time to disposition for Clark County's business court sat at 1,228 days. Fiscal year 23 was better, with an average of time of 656 days. That's still far too long. Nevada is just not set up right now to keep pace with Delaware courts because judges handling the existing business docket often have other dockets to manage as well. It's incredibly challenging to simultaneously manage a criminal docket, a civil docket, and a business court docket, switching from arraignments to personal injury and then to mergers and acquisitions. This resolution would clear business court judges to focus on business law and get matters resolved. Other states are also moving to compete more vigorously for this business by improving their infrastructure and adopting competitive law. Last year, Texas created an appointed business court. Texas business court judges are appointed directly by the Texas governor and serve 2-year terms. Last week, the Texas legislature introduced a bill copying provisions of Nevada corporate law and making additional changes to compete more effectively. This resolution aims to provide a more stable bench than Texas in 2 ways. First, it calls for judges to be selected from a list provided by a nominating commission with a range of important stakeholders. Second, it sets terms to 6 years instead of 2. This means that Nevada would offer a more stable and predictable judicial environment where the business court's composition will not change on a dime if the party controlling the governor's office changes. With that in mind, here are other key provisions of Assembly Joint Resolution 8 codified by the conceptual amendment circulated earlier. The resolution enables the legislature, to the extent funds are available, to provide for the establishment of an appointed business court. Nevada will always need to balance among priorities. This preserves the legislature's flexibility to appropriate funds where they are most needed should there be a funding crisis after the amendment passes. The resolution outlines the exclusive original jurisdiction of the business court, focusing on complex business and commercial disputes. It also empowers the chief judge of the business court to transfer matters to other district courts should the matter be more appropriately adjudicated by another court. It sets the term of office for business court judges at 6 years without any term limit. The resolution preserves the ability of the public to retain a say in the Nevada Judiciary through a retention ballot instead of an election process. The resolution provides for the appointment of a chief judge of the business court by the Chief Justice of the Supreme Court. It makes necessary conforming changes to other sections of the Nevada Constitution to integrate the business court into our judicial system. In conclusion, this resolution modernizes our judicial infrastructure to maintain and enhance our competitive position. However, please keep in mind that this resolution is only a first step. If the legislature approves, and if it is approved in identical form during the 2027 legislative session, the voters will decide the final approval or disapproval in the 2028 general election. Once the legislature gains the constitutional authority to create an appointed business court, it would then need to pass legislation to expend funds and actually establish the business court. Although passing this resolution won't immediately create a business court, it will send a message to the business community that Nevada is committed to creating a stable business environment for the long term. If more startups begin to pick Nevada as their state for incorporations, all Nevadans will benefit from the regular fees they pay to maintain a Nevada entity. This court has the potential to enhance Nevada's economic competitiveness, attract new business, and ensure the swift and expert resolution of complex commercial disputes. I urge your support for this resolution and welcome any questions you might have.
Okay, thank you so much for your presentation. And often as chair, I always have to remind people how to correctly pronounce the name of our state. And it is Nevada, not Delaware. So just wanted to put that out there. So we will begin. We have a number of questions. So the first question will come from Assemblymember Gray.
Thank you, Madam Chair. Keeping in mind we're not a money committee, but the question still remains, who's going to pay for this? Will this be wholly funded out of fees?
So the choice about how to fund this is going to be something for a future legislature to decide. If as I expect will happen, you continue to see increases in entity formation, there may be significantly more fees being paid to more than offset the cost. The court itself will also be able to charge its own filing fees. I know the Delaware Chancery Court charges well over $1,000 a filing.
Thank you, Professor.
And yes, that decision would be made after it would pass through. Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for answering our questions. My question, and really my concern, comes from the appointed judges. Can you just explain why every other judge in the state is elected, and we've determined that that's reasonable for them to be elected, but in this one instance, we want appointed?
Assemblymember Joe Daly for the record. It's a really good question, and we are supportive of appointed judges in other contexts where it might be appropriate. There's two pieces to this one. One, these are some of the most complicated types of cases that we see, and it's not a normal part of the curriculum. So when you go through law school, you're taught civil law, you're taught criminal law. You are not automatically taught business law. And on the bar exam, you're infrequently tested on business law. much to the chagrin of my co-presenter who just took the Nevada State Bar, and it was not a corporate law question. So I think in this situation, because these are such time-consuming cases that drag down the dockets of other types of cases as well, there is a lot of efficiency to be had by concentrating these with experts that are vetted for that expertise to make sure that the whole judiciary functions well for all plaintiffs. Does that answer the question?
Thank you. No, I appreciate that. You know, I think that we hear a lot about judges literally having the power of life and death over folks. And so I just wonder, are you saying that our current judges are not capable of making these decisions today?
Assemblymember Joe Daly, for the record. No, we have actually some very talented judges on the bench right now. The issue that we have is that when you have an elected bench, there's no guarantee, there's no set of spots for we're going to elect this many, family law experts, this many experts in personal injury law, this many experts in business law, and that creates an inefficiency that I think that we're trying to fix here. So they are the current business court happens to be staffed by folks that have commercial litigation experience, but that is kind of a product of random chance. If a certain set of candidates just don't run, then we might have none on the bench, and then we're put in a position where we might be educating a judge in real time on a type of law that they're not familiar with, that now they have to adjudicate that type of case. So that's, sorry, does that answer the question? Sorry. Thank you.
So based on that question, I'm going to dig even deeper, because in the bill it says appoint that the governor from among 3 nominees selected for each individual seat by the Permanent Commission on Judicial Selection. So who appoints, or how does one become get on the Commission of Judicial Selection?
Thank you, Chair. Assemblymember Joe Daly, for the record. So we've amended that piece in our amendment language, the friendly amendment language. So now we are going to, other stakeholders expressed a concern about the commission. So what we're planning to do to give more stakeholders a voice in the process is to have a set of, a special nominating commission formed by the legislature. So this would be part of that enabling legislation in fiscal year 2029, or whatever the case may be, when this would be passed. And the legislature would then set forth the size, composition, and nominating procedures of that commission. But it would include the Speaker of the Assembly at that time, the Senate Majority Leader, the Chief Justice of the Nevada Supreme Court at that time, and the Chief Judges of the 3 most populous district courts. So that would be likely the 8th, the 2nd, and I assume the 1st.
Okay, so that seems pretty consistent with how appointments occur currently in the state. And then would that be approved through the Ledge Commission?
I think we're open to that. We didn't want to set up too many parameters and hamstring the future session too much, but I think that that's an appropriate venue for that.
Okay, so with that though, could you still answer to me who currently, how does one get on the Commission for Judicial Selection?
I'll pass that to my co-presenter.
Ben Edwards, for the record. The Nevada Constitution currently has an existing judicial nominating process, and it includes, I think, representatives of the state bar, appointees by the governor, and it may not have the same degree of legislative influence as this would, and so there's some, I think, geographic restrictions, but I would have to spend some time specifically reviewing the existing constitutional structure. But the thought is that this alternative structure with a commission selected or created for this purpose is going to work better in the future.
Thank you for that. I was just really trying to get at that it just wasn't another example of just ultimate executive powers. That was just it. Thank you so much. We will move on to our next question. Will be from Assemblymember Roth.
Thank you so much, Chair, and thank you for the presentation. Kind of going off, some of what's been said. So it was mentioned, kind of the commingling of cases right now. Our judges hear a wide range of cases, and I've certainly been in the position where I've educated in real time a judge regarding criminal law matters or something like that. So can you explain why a business court? If what we're talking about is an issue with judges hearing subject matters outside of their expertise, there are many judges who are not experts in civil law or criminal law or anything like that. And so why a business court versus a statewide housing court or a statewide consumer protection court or something of that?
Ben Edwards for the record. So here, one of the reasons for an appointed business court in this context is simply for speed of adjudication. So if you have a large public company that is operating in Nevada and they have a deal that they need to close, they can probably close that deal within 90 days in Delaware. Here, the deal might end up on hold for years, and that's I think a real barrier to selecting Nevada, just in terms of the speed of adjudication. But when it comes to there being benefits to specialized expertise across these other areas, you're absolutely right. And we have family courts established specifically for that purpose. And I would not in any way be opposed to creating other specialized courts. But this, again, my area of expertise is generally business law, and I wanted to stay in that lane.
Thank you for that, member. And while this is still fresh in the air, Ms. O'Krent found for us the appointment process for the commission. And so the commission is made up, it's under section 21. It says the commission is comprised of 2 justices or judges appointed by the Supreme Court, 2 members of the State Bar of Nevada, a public corporation created by statute appointed by its Board of Governors, and 3 persons not members of the legal profession appointed by the governor. So if that solidifies a little more thought to where we're at right now, we will move on to Assemblymember Gonzalez.
Thank you so much, Chair, and thank you so much for the presentation. I was kind of wondering if you could speak to Nevada's capacity for a new court. I think even this legislative session, we've heard of how overburdened the courts are, how they're asking for more judges. And so how does that in tandem, in this conversation?
So Ben Edwards for the record. In terms of capacity, for a new court, this is something I think the future legislature is going to have to evaluate. One of the reasons we structured it as enabling legislation is to give that future legislature the ability to look at, where the judiciary is right now, the volume of cases going through, and how many, members or seats would be appropriate to create. So in terms of a funding capacity, if the amendment does generate substantially more confidence, in Nevada being a stable and predictable jurisdiction, then funding it may become substantially easier if revenue from entity formation increases.
Member Gonzalez, does that answer your question? Yes, thank you. Okay, thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you for being here. I don't think I need any more convincing of the need of a business court. Having had some presentations and speaking with some judges about, I even have a constituent in another county that is waiting 2 years in civil court on a business matter and has been defrauded millions of dollars and has had to close their business over this whole situation. So I think the need is there. I think we're here to, and at least in my opinion, talk about some of the mechanics, and I like the baby steps about enabling. And I appreciate your memo. That really was good. It was like frequently asked questions. And I'm like, yeah, these are the questions at hand. Along the lines of appointment, because it is a little bit outside of what we do in Nevada, appointing judges, I do get it. There needs to be a real knowledge in this area of business law. So what is I think you mentioned retention ballot if you could explain that a little bit more. So if we are out of the norm on doing appointments, it seems like our backup then, our safety net is the retention ballot. So if you could go into that a little bit.
Assemblymember Joe Dahlia for the record. Thank you so much for the question and the comments. Yeah, so the retention ballot, essentially the way this would function is that the last election held during that judge's term, they would be subject to essentially a yes/no, right? Voters would be able to say, okay, we've heard enough about this judge. Like, I don't know how they're getting through the appointment process over and over and over again, but we have to have some kind of safety valve to get rid of this judge because it's just, we're not ending up in a good place for the state. This gives them the ability by a 51% or a little over 50, right, to essentially send that judge off the bench, right? In which case, but that's all they're doing, right? They're not electing a new judge. They're just pushing that judge off the docket. And then what would happen is there would be another appointment process. So the same appointment process we've been using is just that judge would then not be eligible for reappointment for that posting. So, thank you.
Thank you so much. We will return to Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for the second bite at the apple. So I have another question about, you talked about we need to expedite and people are waiting 2 years to get through, and I understand that, but we've also heard of folks that are incarcerated and waiting to be heard, and we've heard of folks that are waiting for relief and are waiting years and years for relief. And so I just wondered, can you explain why we are jumping businesses ahead of our constituents in expediting their needs rather than trying to expedite those other issues?
So these other issues are critically important. Again, Ben Edwards, for the record. These other issues are incredibly important. And I see your concern. And one of the challenges I think the state faces is always resources and having the ability to have enough judges to handle all the work that's in front of them. So the benefit of an effective appointed business court is that it makes those resources generally more available. Delaware gets over $2 billion a year in entity fees. It is also my understanding that the judiciary is also coming to you and requesting more judges to handle that workload. This, to some extent, would simply be a reorganization of existing dockets. If judges that are currently handling a civil docket, a criminal docket, and a business court docket, if some subset of them switches exclusively to business court, then those things that are clogging up the other dockets and slowing down relief, like these complex matters, once they're moved to their own forum, they don't slow down other matters, and so this is an efficiency measure. But generally, I am not at all opposed to devoting more resources as well to making it easier for people to get relief in a timely manner. I think it's important.
Thank you. We will also return to Assemblymember Roth.
Thank you so much, Chair. My question is more practical, and maybe you can walk me kind of through the practicality of this is, correct me if I'm wrong, this is enabling language. And so let's say everything goes as planned and a business court is set up and it's filled with judges who understand the complexities of business law, and it brings in an influx of businesses into the state of Nevada. And then we hit a recession, and the enabling language, we now no longer have the funds to fund a business court because we need to put the constitutional rights of our most vulnerable citizens before our corporations, right? So then what happens to those cases? Does the business court just dissolve? Do those cases now with an influx of businesses go back to the district courts where they're going to have issues handling that influx? Like what happens if we reach that scenario?
Assemblymember Joe Dahlia for the record. So just to clarify the question, is the question that if we've already funded the startup costs of the court and then something happens before the next biennium to continue funding the court?
Correct.
Gotcha. Well, in this case, once we've established it, it is established. It'd be like any other district court, right? But I don't envision a scenario, in speaking to stakeholders, the demand for this is overwhelming. And we expect that this is going to, even the passage of this in the process of moving it towards making this a permanent measure, we're going to see an uptick in Secretary of State filing fees. And if that number goes down marginally because we experience a recession, we can't get ahead of that, but we don't ever anticipate a point where the continuing operations costs of the court are not met by its own filing fees and by those Secretary of State fees. We expect that to be covered by an exponential figure. So, thank you.
Sure.
Do we have an actual estimate of what we're going to be bringing in?
Assemblymember Joe Daly for the record. We have a ballpark, so we can kind of situate it between, we're at 200 million right now. 2 billion is Delaware's share. In stakeholders we've talked to, we don't want to be overly optimistic in our estimates, but we've been told that folks expect this to be in the hundreds of millions to the low billion figure for annual new revenue from just this piece. Thank you.
Quickly.
I'm just trying to get to, like, is this evidence-based? Like, where are these data points coming from? And is this based on actual, like, data that we have in the state of Nevada, not based on what we're seeing in Delaware? Because it's apples and oranges, right?
Assemblymember Joe Daly for the record. I do think that they are apples and apples because what Texas and Delaware have done relative to what we're doing, it is all kind of the same thing. In terms of having a figure that we could point to as this is the exact sum we're going to have coming in, short of getting companies to sign a binding contract to agree to come here, I don't know how we could get there, but we do have enough folks in that industry that are telling us that they will start advising their clients to set up shop in Nevada because of this. And you can kind of expand out from that and see that if we can continue to make inroads in that market, and that market is so substantial that it is in the multiple $1 billion, the estimates we're talking about seem very reasonable. Thank you.
Thank you. We have a question from Assemblymember Urick.
Thank you, Chair, and thanks for this very informative presentation. I think my question aligns more probably on trying to get clarification on an issue, and that is, from sitting here listening to the questions and the answers and the presentation itself, it seems less about prioritizing Nevada's business needs over all other criminal and civil litigation matters. But yet it seems to be directed at targeting what is taking up a massive part of our court's dockets in these complex litigation matters. And by removing these and assigning them to where they can be tangentially adjudicated more efficiently, at the same time, it would also free up court's dockets to address in a more timely manner the remaining part of their dockets. Can you clarify that for me, please?
Ben Edwards for the record, and yes, that is a large part of the benefit of this. That by shifting them to a specialized forum, they come out of the space where they're at right now, taking up substantial time. I know for myself when I teach a class the first time, like my dean made me do with property a few years ago, it takes a lot more work to get up to speed and ready to do it. But when you're doing it all the time, you just become so much more efficient. It's one of the reasons we have siloed out, justice court, family court, and I think there are real efficiencies to specialization.
Thank you for that. Our final question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. So my question is, as we all know that there's a need for growing business and this can help in that need. So suppose we have the courts and we have the judges, and my question is regarding that the nomination process, why it has to be nominated, why we cannot go through the election to make it more fair and unbiased?
Ben Edwards, for the record. The challenge with an election process is that you are not always going to be able to guarantee to outside stakeholders that the people who are winning those elections are the ones that that have the expertise. I know from my own experience, voting for judges, I'm very well positioned to be able to figure this out. In that I'm a law professor, a lot of the judges are adjuncts, at the law school. Many of my students go on to clerk for them, and I still am calling around, expending an enormous amount of effort trying to figure out who to vote for in a contested election. And so the challenge is that there's just no way to give clear assurance that the people who are going to win those elections are going to be people with substantial expertise in this particular area of law, and that's the goal, is to ensure that expertise sits on the bench.
Thank you.
Thank you so much. With that, I will go ahead and open it up for testimony in support of AJR8, starting here in Carson City first, again asking that you say your name and spell it for the record, and then please keep your comments to 2 minutes. Whomever would you may choose who wants to begin.
Thank you, Chair Miller and Vice Chair Marzola and the rest of the members here. My name is Jeff Saling, S-A-L-I-N-G. I'm the co-founder of Startup NV and a general partner in several venture capital groups here in the state, as well as being the leader of the Sierra Angels. And I need to make a confession. I'm part of the problem. When founders come to me asking where they should incorporate, I often have to say Delaware. I invest at the earliest stages at pre-seed and seed, and I worry whether or not they'll be able to get follow-on funding if they don't have a Delaware C Corp as their basis. And this happens everywhere, from UNLV and UNR grads to Silicon Valley engineers considering locating their companies here. They hear the same thing from me and others. Either get a Delaware C Corp or you might not get funding after I write a check. So the irony is Delaware's primary advantage has always been their Court of Chancery, the expert judges handling business disputes quickly. And that's exactly what AJR would create for Nevada. And we're witnessing a remarkable opportunity here. Dropbox has already moved to Nevada. TripAdvisor is here. Bill Ackman is bringing Pershing Square to our state. And many other business leaders are advising companies that they should consider seriously incorporating in Nevada versus Delaware. For the first time, business leaders are actually getting behind that thing. So we've got wind at our back. It's time to break the cycle. With AJR8, we could create our own specialized business court. When founders ask me where to incorporate, I could confidently say Nevada. As a Nevadan, that's what I want to say, without setting them up for potential problems in the future. Texas is already doing this. You've heard it a couple of times today. And if we don't do it, we're going to miss out on our share of that $2 billion that's being spent on this in Delaware. Well, how much of it will we get? It's hard to say exactly, but we know we'll get some of it. So in closing, I'd ask you to support AJR8 as a transformative initiative that would change business, change the advice I have to give to the founders who I invest in. Instead of reluctantly saying to send their money to Delaware, I could proudly say, keep it here.
Thank you. Your 2 minutes are up. Thank you. Next.
Good morning, Madam Chair. Good to see you. For the record, Trey Abney, Trayabney, here today representing small business owners of NFIB in Nevada. I will be brief. We support AJR8. We think this would allow for a specific expertise on courts dealing with just business matters. We believe that this will allow other courts that currently exist to serve your constituents more efficiently, and we think that the creation of this court would provide more dollars that you would be able to use to serve the needs of your constituents. And so efficiency, dollars, and then again, serving your constituencies better, both business and the general public. Thank you, Madam Chair.
Madam Chair, thank you again for the opportunity to be here. For the record, my name is John Sandy, Johnsande, here today on behalf of the Las Vegas Sands Corp and the Nevada Franchised Auto Dealers. I'm going to try to finish my 5. I got 3, you might remember. The first one was more jobs, more tax revenues, helping out small businesses and entrepreneurs. The fourth reason that I came up with is that it keeps us competitive and it protects our economic future. A strong corporate sector helps keeps Nevada's economy diverse. Nevada's economy has historically been tied to gaming and tourism. Attracting business and finance, technology, and other industries creates economic stability, reducing reliance on one industry and better preparing Nevadans for economic downturns, which leads into the next one that's particularly important to me, and that's jobs for our next generation. Right now, our economy is, as I said, it's not as diverse as we probably would like it, and I don't know what jobs my kids are going to want to go for, but I would love it if there's a spot for them here in Nevada. And I think that developing this type of environment will allow for that diversity in our economy. And then the last one, when you put all these together, it allows for us to improve public services and infrastructure. Increased business corporation fees and economic activity will help us fund our public education. It'll help us improve our infrastructure and fund public safety. A stronger business climate means more resources for the state to invest in the well-being of all Nevada citizens. So in conclusion, by making Nevada the best choice for business and corporation, we're creating jobs, generating state revenue, supporting small businesses, and strengthening our economy, which directly benefits everyday Nevadans, ensuring a prosperous future for our families, communities, and workforce. Thank you, Madam Chair.
Good morning, Madam Chair, members of the committee. Daniel Stewart, DANIEL STEWART. I'm here in my personal capacity as someone who has litigated in both regular courts and business courts down in the 8th Judicial District in Clark County. And I can say there is a marked difference in how those courts proceed. The business courts are often a slog, millions and millions of pages of documents. And sometimes the judge, or all the times the judges themselves, have to take control over the discovery process in ways that slow down the entire docket. So I've had quite a bit of experience in both. I do enjoy being in business court when I can, when you have very specific topics and expertise that need those resolutions. And so I support this resolution to try to make it something that's worked pretty well in Clark County and Washoe County, I believe, and to expand it beyond the state. Thank you.
Good morning, Madam Chair, members of the committee. For the record, Paul Moradian, PAUL, MORAD, KHAN with the Vegas Chamber. The Chamber is also in support of AJR 8, as you've heard, a dedicated court system with judges with expertise and knowledge, of course, benefits our entire community, increase efficiency in the court systems, and of course, you've heard the potential revenue for the state as well. The extra revenue generated could support other programming needs as directed by this body, but also would help small businesses, owners, and entrepreneurs who are, of course, constituents in each of your districts. Thank you so much.
Good morning, Madam Chair, members of the committee. Brian.
So nice to see you in person now.
Thank you. I was going to apologize. Brian, BRYAN, WACHTER, and I am the Senior Vice President of the Retail Association of Nevada. Unfortunately, this morning, the person I was talking to would not get off the phone, so I couldn't come over here. But very glad to support that other bill and to support AJR 8. You heard a lot of reasons why this is a good bill. But one of the things I want to underscore is this is the type of economic development that is very cheap for the state of Nevada. You are going to consider a multitude of ways that you're approaching economic development. Some of those are going to come with a very heavy price tag. This one does not. And any way that we can, I don't want to say force, but influence business owners, corporate, to be coming here into Nevada, to making Nevada the first thought, is how we're going to grow those corporate jobs, the ones that are more than $25 an hour, the ones that we're really begging GoEd to be looking for. These are those heavy headquarter finance heavy jobs, and those are the ones that I want my kids who are going through the Clark County School District right now to have access to, and any chance that we can have to expand those opportunities for our kids and expand the economic development in Nevada without spending millions of dollars is a win, and that is why we encourage you to pass AJR 8.
Thank you. Is there anyone else here in Carson City? Not seeing anyone, we will move down to Las Vegas. Secretary?
Good morning, Chair. Cisco Aguilar, Secretary of State. At the SOS office, we're focused on modernization, innovation, and transparency. AJR 8 advances these goals. AJR 8 gives us the opportunity to truly advance Nevada. With AJR 8, we will drive higher paying jobs, build a stronger, sustainable economy, and build capital opportunities for small business. Given the work we've done in the SOS office, corporate filing revenue is up over $1 million for the month of February. Every dollar that goes to the general fund, we want this revenue to grow even more so we can grow the general fund and provide Nevada the opportunities they deserve. Thank you.
Thank you so much. Next person. Good to see you, Secretary.
Good morning again, everyone. Amber Stidham, that's Stidham, on behalf of Las Vegas Global Economic Alliance. Thank you for the opportunity to provide remarks. We're also in support of this bill, and being as a regional economic development agency, we spend significant time working to support existing businesses as well as supporting entrepreneurship. We believe that AJR 8 is a tool that can help Nevada's efforts to attract and retain business. And it is a strategic step forward by the legislature and stakeholders to enhance, modernize, and strengthen our business entity statutes. A key component of it, and it had been mentioned earlier, was establishment of obviously the focus of a special judiciary framework really does, in our eyes, position Nevada as a premier state for incorporations. It can serve as a crucial factor to encouraging non-Nevada corporations to incorporate here. And when we say non-Nevada, that also means startups. There is a reason that a state to the east that remains nameless has long been regarded as the top state for incorporation. And largely that is because they are seen as the expert and they have a legacy through their court of chancery, which has provided over a century of informed rulings on corporate and business law, which is incredibly important to businesses as we look to expand and diversify our economy here in Nevada. For all the reasons already mentioned, I won't belabor the point. We do believe that the implementation of this constitutional change is a step in the right direction. And for those reasons, we ask for your support. Thank you.
Thank you so much. And we appreciate the way you pronounce Nevada. Next person, please.
Thank you, Madam Chair. Albert Kovacs, shareholder with Brownstein Hyatt, Farber Schreck in Las Vegas, here only in my personal capacity to support AJR 8. I join the chair's frustration with the pronunciation of the state and often correct people, Nevada over Nevada, and also to clarify that Nevada is not the Delaware of the West. Nevada is Nevada, and we can stand on our own 2 feet, and we do things the right way. We do them the Nevada way. We don't just reflexively and reactively copy what other states do. We take the good, we look at the good, we look at the bad, and then we do the right thing for the state of Nevada. And I think that's what AJR 8 does in this context as well. Having a specialized business court with appointed specialized judges in this area will provide business leaders and their stakeholders with efficient resolution of disputes and complement the hard work that this legislature has done over the years in making our corporate laws currently the envy of the nation, and I say that with great confidence based on the things I hear. It would be a practical benefit to the companies and their stakeholders that are already present in Nevada, and eliminate one of the few speed bumps that are making people hesitate, not because they're concerned with the quality of our judges or our courts, but because of their familiarity with Delaware courts and that inertia. And this would not only be good for the people who are here, but helpful in overcoming that inertia to help people realize that Nevada is a great place to do business, to live, to start, and to grow a business. Thank you.
Thank you so much. Is there anyone else there in support in Las Vegas? Not seeing any. Broadcasting, will you open the lines, please?
If you would like to testify in support of Assembly Joint Resolution 8, please press star 9 now to take your place in the queue. You may begin.
Good morning, Assembly members. My name is Joshua Halen, Joshua Halen, and I'm calling in to testify in support of AJR 8. I'm a business litigation attorney in Reno who practices in business courts in the state. And before that, I actually wrote my law school article, which was published on the need for Nevada to create an independent business court system. The issues that Professor Edwards identified were the same issues that I identified in my law school research and my law school article, which was published in 2016. And I've seen these same issues in practice. Those include business court judges hearing non-business related civil and criminal cases, which lead to the backlog of cases and a slow disposition time, which impacts both business and non-business court cases. Additional issues would include the lack of published opinions and the lack of judicial precedent for the entire state. Creating a dedicated independent business court system in Nevada will address these current shortcomings of the current Nevada business court system, which will hopefully contribute to new and sophisticated businesses relocating or incorporating in Nevada. And one additional issue in creating an independent business court system with jurisdiction over the entire state will ensure better access to experienced business court judges for rural businesses. Currently, we only have business courts in Washoe and Clark County, and a new system would provide experienced judges for all businesses throughout the entire state. Thank you.
If you have recently joined and would like to testify in support of Assembly Joint Resolution 8, please press star 9 now to take your place in the queue. Chair, there are no other callers wishing to testify in support at this time.
Thank you so much. Then I will open it up for testimony in opposition, beginning here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas? Not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Joint Resolution 8, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you so much. Then I will open it up for neutral testimony. Is there anyone wishing to testify here in neutral in Carson? Anyone in Las Vegas? Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Joint Resolution 8, please press star 9 now to take your place in the queue. There are no callers wishing to testify in neutral at this time.
Thank you so much. Then I will welcome the presenters back for very brief comments. And when I say brief, I mean brief.
Assemblymember Joe Dahlia for the record. Chair Miller, thank you so much for hearing us out today. We will not belabor the point. We will continue to work with stakeholders and with you all on this. Thank you.
Thank you. Thank you so much. With that, I will go ahead and close the hearing on AJR 8. Our final work today is for public comment on our agenda. So is there anyone here in Carson City wishing to make public comment? Is there anyone in Las Vegas? Broadcasting, will you open the lines for public comment, please?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now. Chair, there are no callers wishing to provide public comment at this time.
Thank you so much. Then I will go ahead and close public comment, and that completes the business before us today. I will adjourn this meeting and see you all tomorrow at 8 a.m.